in sharp contrast to an insanity evaluation. At an insanity evaluation, what the psychiatrist will do is they will assess the person's mental state at the time of the incident. They will, let's say, try to see what a person's mental state of mind was like when a killing occurred, when a killing was committed. And notice I'm not necessarily saying that it was a murder,
right.
because if the judge or jury decides that a person is not guilty by reason of insanity, that means that they technically are not guilty of murder.
Okay.
So to go back to competency and insanity, people constantly mix up these two.
Okay.
They constantly confuse the idea that competency and insanity are the same thing, but they absolutely are not. What typically will happen is that if a person is arrested somewhere in Rhode Island, they will have some sort of behavior either at the local lockup or when they appear in front of a judge or magistrate at some initial hearing. And somebody there is going to have some concern about whether a person has the mental capacity or the wherewithal to be in court at that particular moment. And judges are very concerned about this. It's important to remember that the law's sense of fairness would be violated if a person who is mentally incompetent is simply taken through the criminal justice process. And let's say they end up pleading guilty and get a sentence and go on to serve time at the adult correctional institution. This would not be a fair process. That's why judges are very concerned about competency. As a rule, when we evaluate these individuals for competency, well, you either make bail or you don't. If you don't make bail, you go to the ACI. And then a screening evaluation of competency occurs, usually within 5 days. And we let the courts know whether we think that they're mentally competent, that is, whether they're able to currently proceed back to court or not. About 80% of the time, we recommend the individual as competent. And that is a statistic that has held generally true within Rhode Island for a number of years. And it also is a statistic that holds generally true across the rest of the country. In other jurisdictions, about 70 to 90% of people are recommended to the court as competent to stand trial. It is only the incompetents that we assess that get transferred to the forensic unit. And they end up getting transferred for a legal term called competency restoration.
Okay.
And that's where the real work begins with these individuals. By that time, what we're saying to the court is that by reason of the person's mental illness, they are not able to be present in court because they either don't understand their charges or they have trouble understanding what's going to happen to them in court, or they don't have the ability to work with their lawyer, or they can't make decisions about their case as the court process unfolds. And so we basically temporarily suspend all of the legal proceedings until that person has received treatment, including some of the programs that I've already described to you. And then, after a time, we will recommend that person as mentally competent to stand trial. And what that means is we let the court know that we, from a medical perspective, believe that the person is now mentally ready to go back to court, so that you can unclick the pause button and have that person proceed and go right through the criminal justice system again. And most people don't understand this. They think if someone is incompetent, then that's that, and the person would never go back to court. They think that a person is somehow beating the system, and that is simply not the case. The person receives treatment for as long as it is really felt that they need treatment. And we do not recommend them to the court as competent until we really believe that they have benefited from their treatment, and we think that they're really able to go back.
Okay. Now, if a person is not deemed competent, then the whole notion we have in our world of providers the notion of the forensic hold. A person that is not yet deemed competent could be placed under a forensic hold.
Yes.
And then remanded back into the community while they were reestablishing competency, correct?
Yes.
Okay. Because we've had folks in our agency over the years that have had forensic hold status. And it allowed us the flexibility to work with some folks, knowing that if they weren't able to do it successfully, then they would be remanded back to the forensic unit for continued inpatient treatment.
Right. You raise an interesting point. Sometimes when these individuals come to our attention, we realize that the reason for their incompetency may be something like the following. Either they are developmentally delayed, they might be mentally retarded, for example, or they have such a serious form of mental illness like schizophrenia that it's going to take many, many months for them to get better. What we like to do when possible is work with an outside agency and work with the courts to come upon an agreement where that person's forensic commitment will continue to hold. They'll still be in the community under forensic commitment, but they can go out into the community and you can spend some of the time that's necessary for that person to get better, the time that's necessary for that person to learn more about the criminal justice system. And we like to see, we like to have the person use that time to develop a good working relationship with an outside treatment provider to get them into care and treatment in the community. And when that happens, it is often successful. And it's a very nice way often of demonstrating to the court that the person is doing well in the community. It's a way of demonstrating to the court that with the level of services that we can provide, we can continue to care for this person, and it can often eliminate the need in the minds of the criminal justice system that this person has to go to jail. So sometimes you can work out a deal that includes probation and continued outpatient treatment. So there are many times when this form of treatment is successful, and it's something that we work for whenever we can.
Right. And we've actually been very fortunate in our relationship with you to be able to have some folks come out and do very well.
Yes.
Under the forensic hold status.
Yes. And when people do not do well, they come back immediately to the forensic unit.
Right. And I think that that's important for folks to understand, because I think on the civil side of doing mental health work, oftentimes if a person is not doing well, then they may be remanded to a local acute psychiatric care facility. And then maybe in 10 days someone's saying that it's time for them to come back out again, but they may not be actually ready at that point. And there's a nice arrangement with the forensic hold that the person is remanded, and then when they are again stable, then they would come back out to us.
Absolutely.
So it works out very well.
if it takes 2 weeks or a month or a couple of months, we simply do our best to give the person time to recover from their illness or for their symptoms to go into as good a remission as possible.
Okay. When you were talking about the idea of regaining competency, you mentioned developmental disabilities.
Yes.
Now, I had always thought, until we talked prior to the show, that the Slater method, which I understand that you had developed in terms of reestablishing competency, was sort of a generalized competency evaluation, but you had said that it's for a specific subgroup of folks that you work with, correct?
Correct. The Slater method is a method that was developed by me and Dr. Brandon Krupp and Dr. Thomas Gilmette, along with others at the Eleanor Slater Hospital, specifically for competency restoration of persons that need more time, more one-on-one work to become competent to stand trial. And the Slater method is usually applied or is provided to people who are developmentally delayed or who have mental retardation. This is a small subset of the forensic mental health population, but it is an important subset of individuals. Because many people who are developmentally disabled, who had been in special education, they didn't necessarily have civics class. They don't necessarily have a lot of experience with the criminal justice system. So they often need a lot of basic education about the court process that persons who did not have special education, persons who have average or above average intelligence would know about and maybe would have had experience with.